Beginning in the 1870s, the governments of Canada and the Christian churches, lacking cultural empathy, began forcibly removing First Nations children from their families and placing them in residential schools to assimilate them under the guise of Christian education. In the 60s scoop, children were removed from their homes and adopted out to non-Indigenous families, severing their ties with their culture and communities. Within the residential schools, the Canadian government used a variety of abusive techniques to eradicate the Indigenous culture. The practices went on until 1996, resulting in more than 150,000 children who were impacted by the abuse within the 150 years the residential schools were running. Social workers were insensitive to the effects of colonization, causing the amount of First Nations children to be placed in out-of-home care to increase by 71% between 1995 and 2001, meaning they were being taken from their families at 6 to 8 times the rate of other children. The proportion of First Nations children in child welfare has surpassed those taken to residential schools. Poverty, poor housing, and substance misuse, often causing neglect, can be attributed to the government's failure in legislating affecting Indigenous communities and to the resulting intergenerational trauma from the dark history caused by the Canadian government. Contributing to poverty, the Indian Acts makes it very difficult for First Nations to generate revenue linked by land ownership. Federal funding for elementary schools on reserves falls short by 40% and by 70% of secondary schools. The government also fails in housing and publicly funded volunteer sectors supporting the Indigenous communities, including food banks, social housing, and domestic violence programs. Many received no such support. First Nations began establishing their own child welfare agencies in the 1970s. They had some positive impacts, but were greatly limited by culturally insensitive provincial legislation and lack of federal government funding.
The First Nations Child and Family Caring Society and the Assembly of First Nations chose a human rights complaint over other legal options, as the Canadian Human Rights Act of 1985 allows for specific relief and enforcement in federal court. In February 2007, the AFN and Caring Society filed a human rights complaint under the Canadian Human Rights Act, claiming that the Government of Canada discriminates against First Nations children by providing less funding for child welfare on reserves. Although the AFN is inadequately funded by the government, the Caring Society raised legal funds through fundraisers and donations. This is in contrast to the Government of Canada, which is able to draw on taxpayer money. In September 2008, when the complaint was accepted, the Canadian government sought to dismiss the case, claiming funding wasn't a good or service under the Canadian Human Rights Act. They also argued that the act required a comparator group to First Nations children on reserves. The AFN and Caring Society countered that child welfare laws apply to all children, eliminating the need for a comparator group. This is reinforced by the federal government's program manual and the Canadian Charter of Rights and Freedoms. The Government of Canada claimed that all on-reserve children receive equal funding. Then they claimed that equal funding was not required because the program manual states that child welfare services for Indigenous children living on reserve are not meant to be identical to child welfare services for other children. Then they claimed that the funding was equal, despite no evidence. In 2009, Canada opposed granting interested party status to Amnesty International Canada and the Chiefs of Ontario, and sought a delay until January 2010. The tribunal granted the status regardless. In November 2009, a newly appointed tribunal chair did not show up for unknown reasons. The Canadian government attempted once more to dismiss the trial, still arguing funding is not a service. They lost, appealed again, and lost again. Canada tried again to dismiss the case in June 2010.
Canada opposed having its witnesses publicly cross-examined and blocked the Aboriginal People's Television Network's request to broadcast the tribunal. On May 28, 2010, the tribunal chair sided with Canada, and the APTN filed an appeal. The I Am a Witness campaign was launched to engage the public, encouraging people to follow the tribunal via the internet and its presentations. Public pressure has been a powerful force in similar cases, such as in the enactment of Jordan's Principle. Jordan's Principle is a law based on Jordan River Anderson of Norway House Cree Nation, who was prevented from going home from hospital for 3 years while the provincial government of Manitoba argued with the federal government over who should cover the costs of his medical care. Because of this, Jordan died in hospital at the age of 5, having never experienced life in a family home. Jordan's Principle was passed in 2007 as a private member's motion in the House of Commons, which made it so that the government of first contact would cover costs and disputes about payment would be settled later. However, the Government of Canada implemented a narrow definition of Jordan's Principle so that no child would ever be able to benefit from it. For a child to qualify, they needed to have multiple disabilities and service providers. This definition was fought in 2013 in court by Jeremy Miasides and Marina Beadle, a disabled teenager, and his mother from Pictou Landing First Nation. Canada would not pay for a level of care sufficient to meet his needs, going off an old policy that had already been ruled unlawful. This was the first court ruling encouraging the full implementation of Jordan's Principle among all government services, but still, the government refused to change their definition to reflect the federal court order. The Canadian Human Rights Tribunal found the definition to be discriminatory and ordered the government to change it. However, in 2016, their unfair definition of Jordan's Principle was still being used to deny First Nations children medical care.